Welcome and thank you for joining Seyfarth's webinar to kick off the release of the 2022 California Peculiarities publication, 2022 Cal-Peculiarities, How California Employment Law is Different. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the presentation. At this time, I'd like to turn the program over to Chelsea Mesa.
Hi, everyone. We're so glad that you've decided to join us today. We know that CalPEX is something that everybody really looks forward to. We always get a really good attendance for this webinar to help kick us off. And as all of you know very well, California is one of the most challenging places to have employees. There's so much that's different. There's so much that's new. And so having that CalPEX resource that I'm sure all of you have already downloaded and are rifling through right now is a great way to ensure you are on top of the new. And so we do think that having a webinar to go through some of the biggest ticket items that are new for 2022 is a great way to deal with this. There's a lot to cover today, so my partners and I are going to do our best to get through all of it. But on the next slide, you'll see our agenda, which I won't spend a ton of time on because that will really give you an indication of just how much there is to tackle. We will go through all 13 of these items just about as quickly as we can, so we can make sure to touch on these things. And as was mentioned, if there are questions as we go, feel free to put them into the Q&A and we'll do our best to try to address them or get back to you with responses to them. But you'll see we're going to spend a little bit of time on some COVID related things. We'll talk a little bit about some of the new time off rules that are going on in California, some interesting nuanced warehouse distribution center quotas. We'll talk about the minimum wage and how that's changed as well. Talk a little bit about regular rate. Give you some good news, bad news on some recent Supreme Court decisions that have come through, including some things around rounding and meal periods. We will give you your favorite topic. We'll talk about PAGA for just a little bit. And as I mentioned, some good news around suitable seating. Then finish up with a little bit on settlements and separation agreements, a little bit on CFRA and how it's changed in the last couple of years. And then at the very end, Anne-Marie's going to give us a little bit of an overview on the Great Resignation and just really what it means to have a great workplace culture and how to determine what might be necessary in order to do that. On the next slide, you'll see all of us, but we'll be talking at you over the next 90 minutes, so you'll be very familiar with all of us. Three partners, all of us in various of the Los Angeles offices. We've got Leo Lee, myself, and Anne-Marie Zalatel, and we'll all have an opportunity to work through the topics that we're going to be discussing today. I'll go ahead and start with the first one. I think it's always good to get COVID out of the way. Hopefully we're all feeling that we're moving past that. And a lot of what we're going to be talking about today is not COVID related, which is great. It seems that the legislature and courts had an opportunity to focus on other things this year. So it's not going to only be COVID on the agenda, but we will start, I think, in the same place we started last year, which was with COVID-19 supplemental sick pay. And as you are probably aware, California's had COVID supplemental sick over the last couple of years. They ebb and flow. The last one, 2021's, expired in September, at the end of September last year. And we went several months without knowing what was going to happen. But in February, the newest iteration, a little bit different than what we had in previous years, came into effect, and it was retroactive back to January and will expire, at least it's scheduled to expire at the end of September this year as well. And it is available very similar to the way that COVID supplemental leave was available in years past for a variety of reasons when an employee cannot work due to COVID-19 related reasons. And so we'll go over those on the next slide. The main difference between the way this is managed when compared to previous years is that we've got two different buckets of sick leave that's available for covered employees. There's one simple bucket that if an employee or their family member tests positive, they've got up to 40 hours to use if they're a full-time employee. The second bucket is for a different variety of reasons. For example, if there's a quarantine or isolation order in play, or a healthcare provider advises that the employee not work, or they've got a vaccine related appointment and then they have got symptoms for getting the vaccine, or they've got symptoms of COVID-19 and they're seeking a diagnosis, or they're caring for a family member, a child whose school has closed due to COVID on site. And so it is possible that an employee might need to tap into both of those, either at different times or one right after the other. You could certainly envision a scenario where someone would need the full 80 hours, but they are earmarked differently. And the way that they're addressed is that an employee wouldn't need more than 80 hours or wouldn't be entitled to more than 80 hours of COVID leave under both the buckets when put together. Now, on the next slide, you'll see there are some other things that employers can do, including asking for documentation when we're talking about that positive test. We also have the ability to require tests for employees and pay for those tests. If the employee is, after 5 days of being positive for COVID, we can require tests. We also can push back a little bit if we've got somebody who, for example, is saying they're experiencing symptoms of the vaccine for more than 3 days. We've got the ability to seek documentation, or if we've got a reasonable belief, and obviously we don't know exactly what that means, but a reasonable belief that the requested leave is invalid. Someone says they're under an isolation order and we see them out and about in the city, then clearly under those circumstances we would have a little bit of a better leg to stand on to seek additional documentation for somebody on a leave of absence for COVID related reasons. Now, on the next slide, another one of the differences here, when we talk about the rate of pay and wage statement requirements, we know under the previous iterations of these laws, the rate of pay was a little bit trickier. This feels a little bit more like the sick time law in California, where we can choose to pay either regular rate or use a 90-day look-back method, although the 90-day look-back method is worded just a little bit differently. We do, though, have the cap that existed under the previous laws so that we don't have to pay more than $511 per day. That cap is from the CFRA. It has been in place since kind of the beginning of COVID, and so you'll see that familiar language. And instead of having to show the amount that's available for an employee to use, because of this dual bucket system and the difficulty of being able to predict what somebody might need to use, we're actually only putting the amount that an employee has used on their wage statements. And so if they haven't used any, it should just say 0. We do need to have that there, but as they are using it, we would be counting up instead of counting down. So that's a very different requirement than we had under the previous versions of this law. And just to wrap up in this section, keeping in mind, we do still, on the next slide, have some local ordinances still in place around, COVID supplemental sick. Many of them sunsetted at the end or September of 2021, but there are several that actually rely specifically on the end of the period of emergency, and those are still in place. Those include the city of Los Angeles, the unincorporated areas of the county of Los Angeles, Oakland, and a few others. And one of the things to keep in mind is that they can arguably run concurrently with some of the California COVID leave, but the rules or the reasons for use don't completely overlap. And so there is a potential somebody in the jurisdictions where the sick leave rules or the supplemental sick leave rules are a little bit different might be entitled to additional time. And so that balance is actually really important to keep in mind. There's also the possibility, and you'll see this on the next slide, that some of the areas where supplemental sick time did sunset, there might still be a sick time law in place that there is guidance that they should be allowed to use it for more expanded reasons. And so we should be really keeping that in mind as well if someone is trying to use their regular sick time for something related to COVID that isn't strictly laid out in the original sick time law. There may be guidance that we should be allowing them to use it for that purpose as well. And with that, I will kick it over to Anne Marie to talk about another aspect of COVID related protections. Anne Marie?
Definitely want to highlight Cal OSHA COVID-19 ETS, or Emergency Temporary Standards exclusion pay. Before I do so, a little bit of background. This is, I'm sure, a refresher for most of you. But back in November of 2020, Cal-OSHA first adopted COVID-19 emergency temporary standards. And those then were amended about a year later, back in December of 2021. They became effective at the beginning of this year in January 14th. And while they were set to expire on May 5th, as we predicted at Cal-OSHA's April 21st meeting, the board voted to readopt the ETS with some amendments. And the current ETS is set to expire on December 31st of this year. But, you know, at this point, the board has indicated that they are considering a broader permanent infectious disease standard. So it would apply anytime there was, you know, a pandemic, wouldn't be, you know, limited to COVID, but it would be modeled after the latest and current version of the ETS. So that's something to be out on the lookout for. Next slide, please. So the ETS has really broad application. It applies to all employers and employees and places of employment in California, except when there's a work location where there is only one employee who does not have contact with any other people. And by any other people, that means both other employees as well as, you know, customers, members of the public, vendors, suppliers. The person literally has to be working alone. It also does not apply to employees who are working exclusively remotely from home, or, you know, to situations where employees are, you know, choosing to work, have the ability to work from any location remotely, and they're at a location that is not under the employer's control. So for example, at a Starbucks, or, you know, at a friend's home. Of course, we don't have any control what the health and safety protocols are in those locations. And then the ETS also does not apply to employees who are covered under the, there's another set of standards. It's the Aerosol Transmissible Diseases Regulation. And it's essentially special standards that apply to skilled nursing facilities, hospitals, medical offices, similar healthcare facilities, because as you can imagine, there are stricter requirements in those locations. Next slide. So, well, you know, we could talk about the ETS for the entire 90 minutes of this webinar. We have so many other topics to get to. So I just want to highlight the exclusion pay, because this is something that is really important, and there's been a significant change from 2021. And because we're focused on 2022 developments, definitely want to bring this to your attention if you're not already aware. So exclusion pay, it applies only when someone is excluded from the workplace because they have COVID, or they've been exposed to COVID at work, or they contracted COVID in the workplace. So it's workplace exposure or workplace COVID. So if they got COVID at a barbecue, you know, while they are on vacation, while they certainly may be entitled to the 2022 supplemental COVID sick leave that Chelsea spoke about, they're not entitled to exclusion pay. But if it's associated with work, then they are for the entire duration of their absence. So it's typically between 5 and 10 days. Also, the rate of pay for exclusion pay is the employee's regular rate for the pay period in which they're excluded. So this is a little bit of a change or a difference, because typically the regular rate of pay is calculated based on the work week, not the pay period. So if you've got people who are paid semi-monthly or bi-weekly, it's going to be a different rate since it's calculated based on the pay period rather than the work week. Also, all other rights, seniority, and other benefits, they continue during this period of time. And this is the big difference. So back in 2021, before exclusion pay was due, an employer could require the employee to exhaust all of their supplemental paid sick leave and California paid sick leave. That is not the case in 2022. So if exclusion pay is due because of a work-related exposure or work-related case of COVID, the employee gets to keep their 2022 supplemental sick leave, save it for another day, perhaps when they need to care for a family member who has COVID, or they're going to get their vaccine, or for one of the many other purposes that that supplemental sick leave applies to. Next slide, please. So couple of exceptions to exclusion pay. It's not owed if the employee is not able to work. So if they can, they've been exposed to COVID, but they're symptom-free and able to work remotely, they can be required to work. Also, they may have tested positive for COVID, but they don't have any symptoms and they're available to work remotely. In that case, they continue to work and receive their regular pay. Also, if you can show that it's more likely that the employee contracted COVID or was exposed to COVID outside of the workplace, exclusion pay is not owed. Also, if the employee is receiving workers' compensation or disability benefits, because the purpose of the ETS exclusion pay is to make employees whole, not to give them a windfall. Next slide. So with that, I am going to turn it back over to Chelsea to talk about West Hollywood's new compensated paid time off law.
Great, thank you so much. This one is new and exciting, is one way of characterizing it. It's very different than some of the paid sick leave laws that we've seen in other jurisdictions, because when you compare West Hollywood to essentially everyone else in California, this is the only law that is set to provide a broader scope of paid time off. It requires that employees receive a compensated time off, not just paid sick leave. It's actually styled really closely around the Los Angeles hotel workers ordinance that's been in place for many, many years. And when that came out originally, when we've got this new draft of this law, I think everybody had a bit of a panic because there were a lot of things about that law that were very challenging for employers. The high level of accrual that is required, the kind of accrual cap that's annual, as well as the point in time cap. And there was, and we'll talk about this in just a moment, there was a cash out requirement. So if somebody were to hit the cap, there was a requirement that individuals would have to be paid for the time out they would have earned had there not been a cap every 30 days. And the good news is we got some guidance earlier in this year that has removed that requirement of cash out. So that's one thing that employers can feel a little bit more comfortable as this goes into play. It's been in effect for about 2 weeks for regular non-hotel employees in the city of West Hollywood. And so we are looking at something that's just a little bit more involved than your regular paid sick leave ordinances that we've been dealing with in California over the last several years. On the next slide, you'll see the effective dates. As I mentioned, July 1st was for all other employees, but it had been already in effect for hotel employers as of January 1st of this year. And just to be very clear, they define what that means. Hotel employer, and hotel worker, all of that is included in the ordinance. Independent contractors, of course, not covered by this law. And on the next slide, you'll see the way in which this compensated time off law is designed to work. There is an accrual rate that would be the equivalent of no less than 96 hours a year, so essentially 50 seconds of hours compensated each week for in the calendar year. And of course, this is prorated or allowed to be prorated for part-time employees. That means the annual accrual cap is designed around that full-time employee earning 96 hours per year. And the point in time accrual cap, just like a traditional vacation policy, would be 192, so 2 times the annual accrual. There's also a requirement for uncompensated time off in addition to the 96 hours of compensated time off at 80 hours a year, so an annualized 80 hours a year, and that annual accrual cap is 80 hours. That's specifically to use for sick leave purposes after the compensated time off has been exhausted. And so someone can accrue that, have it ready to be used, but there's not a paid component to it. And if they end up exhausting all of their compensated time off, this uncompensated time off is there and available for them to use and take unpaid time off for sick time reasons. Now, if you look at the rules on the next slide, you can see that there is the permission of front loading because this is compensated time off, paid time off, and there is that blend with the vacation laws. Front loading, we know, can be a little bit of a challenge. But if, for example, and we'll talk about this in just a moment, you wanted to split the buckets and give a piece of sick time and a piece of vacation, you could certainly front load the sick time problem without much issue. And so that's something that you could consider doing. And then there is, of course, the year-end carryover that we talked about just a moment ago, and no apparent cap on annual use. And so obviously, if somebody stockpiles their time, they've got a lot more to use. They would be able to use more than the 96 hours in a year without any, any prohibition on that. And I did talk about that guidance that we got just a couple of months ago, making it clear that the monthly cash out is off the table. And so if you were planning on making those payments to your employees as the months go by, this isn't something that we have to do anymore, thankfully, under the West Hollywood ordinance, where there's not a need to do that for our employees going forward. We also got good guidance that we can comply with the West Hollywood ordinance by splitting the buckets. That was something that wasn't clear in the original iteration of the law. If we wanted to, for example, provide a bucket of sick time and a bucket of vacation time and allow employees to have those kind of separate buckets, we are allowed to do that. So it's one option is the paid time off bucket, but another option is to give at least 50% of that time in vacation and then the remainder in sick time. And so we do have that option, and a lot of employers we've seen are choosing to go that route because then you can manage vacation knowing that there are vacation laws in play. You can manage the sick time knowing that there is still California paid sick leave requirements that would apply to that bucket as well. I think it makes it a little bit easier for employers to manage, but we are seeing sort of both ways occur. And because it is a compensated time off ordinance, on the next slide, we can see that the reasons for use are not as limited, of course, as they would be under the California sick time law or, even vacation. If it's given all in one bucket, the employee essentially gets to choose what they use it for. And then if we split it up, one would be used for sick time as per the, the California paid sick leave law requirements, and one bucket would be used for vacation. And so you could essentially see how that would play out. But of course, the uncompensated time that we spoke about just a minute ago, on the next slide, please, we can see that is only to be used for sick time purposes. And so it's illness of the employee or their immediate family member. And immediate family is defined under CFRA, which we will talk about later in our presentation today. But of course, we want to be mindful that an employee may have, the sort of that need to take the time off for themselves as well as their family member, that kind of kin care aspect to our laws. There is a waiting period. On the next slide, you'll see that there is a waiting period that is allowed. And the waiting period does tend, on the next slide, please, to be a little bit longer than the waiting period under the California paid sick leave laws, but we have to keep in mind that the employee is going to get the most generous, the most beneficial, so that we really can't go longer than 90 days to allow an employee to use the time for sick time purposes. So we should be aware of that. There is no rule around increments of use, so we should look to the sick time law, California sick time law, for that as well. And we know that we cannot require more than reasonable notice from an employee on when they're noticed to use it. And that's, again, very similar to what we should be looking for in the California sick time law as well. The next slide addresses notice and posting requirements. There are notices. We've got the links here, and you will receive these materials. You'll be able to click directly on these links to be able to get what is necessary if you're a hotel or you are not a hotel, another business in West Hollywood. And so we do need to have these notices posted for our employees to be able to review what their entitlements are. That's very important as well. And then, of course, on the last slide in this section, you can see that from a separation of employment perspective, depending on how you provide this time, you may have to pay out some measure of it. If you're using multiple buckets, of course, we know under California law, the vacation time would have to be paid out and sick time would not. But if you're using that one bucket system, obviously that time would all have to be paid out as PTO on termination of employment. And there is a reinstatement provision that is very similar to how it is structured under the California paid sick time law. If an employee leaves your employment and we didn't pay out the measure of sick time, that employee would be able to get that sick time back when they start if they rehire within a year. So there are some similarities, but a lot of differences now that we're looking at it. It's very different because it does have much broader requirements. And so obviously this is one of those that you have to be really careful when you're implementing to make sure that you hit all of the nuances of this particular ordinance as well as the California vacation laws, as well as California paid sick leave laws, because those don't go away just because we've got West Hollywood's ordinance that addresses PTO. And with that, I will kick it back to Anne Marie. I guess we're tag teaming in just a little bit in the beginning to talk about the warehouse distribution center quotas.
Thank you very much, Chelsea. And we know that most of you don't have warehouse distribution centers, but we do want to spend just a little bit of time covering this topic, because for those of clients who do have warehouse distribution centers, we have been fielding a lot of questions on this new law, which is pretty unusual even for California. So it's known as AB, or Assembly Bill 701. It went into effect earlier this year on January 1st. And what the law does is it essentially requires employers, covered employers, those with more than 100 employees at a single warehouse distribution center, to provide written notice of anytime a quota applies. And a quota is actually a defined term in the statute. Got your definition, on the screen here, but it's basically a work standard. So if an employee is required to meet certain standards, whether it's, productivity, speed, or, produce a certain quantity of, or complete a certain quantity of tasks, or handle a certain amount of material, that is what a quota is. Next slide, please. So if the employee is subject to a quota, then this notice requirement applies, and the notice must include the 3 items on the slide here. So the number of tasks that the employee is required to perform. Also the relevant time period. Are they judged by the day, by the week, or by the month, or some other time period? And then finally, any potential adverse action that could result from failure to meet the quota. Are they subject to discipline? Will they be terminated? Also, what the law does is, and this is one of the purposes of the law, is there were reports that from employees who had worked in these warehouse distribution centers that they couldn't take their meal and rest breaks, because if they did, then they would be fired or disciplined, because it was impossible for them to meet the quotas if they complied with the break and meal requirements. So employers are expressly prohibited from, imposing quotas that prevent them from complying with the meal and rest and other health and safety requirements and use of restrooms, et cetera. Also, employers cannot take any adverse action if the quota has not been disclosed, or the quota does not enable a worker to comply with the meal and rest period requirements or health and safety standards. And with that, I am going to turn it back to Chelsea to talk briefly about California minimum wage laws.
Yes, indeed. Very briefly. Not a ton to discuss here. More of a reminder. Hopefully everybody's already aware of these changes since they've been in play for several years, and especially this year, the last several months. As a reminder, minimum wage in California is significantly higher than the federal minimum wage of $7.25, and the federal construction and service contract worker minimum wage of $11.25. We are, if you are a larger employer, meaning more than 25 employees, we are at $15 in California now. Next year, we will be at $15 for all employers. And that's, of course, unless, there's a law that gets passed that raises it even further after that. But know that California will be no less than $15 minimum wage for all California employees starting, even small employer ones starting at the beginning of next year. On the next slide, we'll see how that impacts our exempt employees in California. As you probably all know, California exempt employees are essentially paid 2 times the minimum wage. And so we do the math. If you are a larger employer, 15 times, 2080 times 2 is 62,400. So that is the threshold if you are a large employer for your exempt employees. Obviously, for a smaller employer at the beginning of this year, it went to 58,240. It'll go to 62,400 at the beginning of 2023. And we know that the salary threshold is based on state minimum wage. And so local ordinances, regional ordinances are not going to impact that. Those are the minimum thresholds, and they're based on the state minimum wage and state minimum wage alone. And then just on the next 2 slides, some examples of locations notably higher than the state minimum wage, ranging from between a little more than $15 to over $17 an hour. A lot of the Bay Area cities are above 15 and have been above 15 for a little while. So we've got 1632 in San Francisco. We've got 1713 in Emeryville, and we'll also see on the next slide some of these additional cities. Mountain View at 1710, Sunnyvale at 1710. Again, very consistent with the Bay Area. Silicon Valley, we do see a much higher minimum wage, but really, we're all over the place, ranging in that, above 15 to all the way above 17, kind of peppered throughout the state. There are several others besides these, but these are a good example of where we are. And since we're talking about wage an hour now, we wanted to invite our partner Leo into this party and give him the opportunity to talk about some of the really interesting aspects and what we've seen lately in terms of regular rate. Leo?
Thank you, Chelsea. From the litigation front, we have seen regular rate cases to continue to be on the rise. We are seeing more plaintiff lawyers filing class actions solely based on regular rate violations. And these cases often start with a pre-litigation demand letter that a lawyer purportedly to represent a former employee. And the pre-litigation letter will ask for a whole host of information, personnel files, time records, payroll records, and maybe some other types of records. Oftentimes, an unwary employer would turn over everything to the other side and allow the savvy lawyer to look through regular rate problems. So on a side note, before we jump into the regular rate, I want to emphasize the importance to consult with in-house and outside counsel in these type of situations to properly assess the risk involved and as well as making a very calculated response to these type of requests. So what is regular rate of pay? Under federal law, the regular rate of pay means everything that employees received, subject to some limitations or exceptions. These exceptions, some common ones are holiday gifts, expense reimbursement payments, certain premiums payments such as overtime pay, and discretionary bonuses. Now in California, the phrase regular rate of pay was never defined in the California Labor Code. So historically, California generally followed the federal law on this issue. This, however, changed in 2018 when the California Supreme Court issued a decision in Alvarado versus Dart. It changed how California calculate regular rate for flat sum bonuses. So I hope most of you have already know about the Alvarado Dart case or the Dart method of calculation. And if you have not and you pay bonuses to non-exempt employees, I highly encourage you to consult either your in-house person or outside counsel on this issue because it's a very trendy topic. Now, on the next slide, we'll talk about why regular rate is such a hot topic and a trendy pick for these plaintiff lawyers. Well, the law on regular rate is largely unsettled. There are two aspects of this. On the one hand, you have a dispute or debate about what type of compensation should be included in the regular rate and what's not included in the regular rate. So for instance, you can have an employer pay a type of bonus that is designed to be discretionary. And under the federal statute and also California law, discretionary bonuses can be excluded from regular rate of pay. But a lot of times the employers overlook some aspects of their complex compensation system. So that gives rise to potential class-wide liability on whether there is a regular rate violation. Now, on the other hand, you have this issue of what method to use for calculating the regular rate. With the Dart, Alvarado versus Dart, now everything's in flux. Employers are often find themselves in a difficult spot to find the right method of calculation, whether it's under the FLSA federal method calculation or the California Dart method calculation. The second reason why these regular rate cases are on the rise is because it's very difficult to comply with all these hyper-technical violations. We see a lot of the clients having technological challenges, and employers with a complex compensation system often experience a lack of support from their in-house or outside payroll vendors to properly calculate the regular rate. Some bonuses require a different look-back period. It could be a weekly, bi-weekly, quarterly, 90 days, or annually. So it creates some logistical difficulties for a lot of the employers. And in the last couple of years, to complicate this issue, we have many employers who want to do the nice thing and provide additional compensation to employees during this COVID-19 pandemic, whether it's hazard pay or some other type of incentive pay. These decisions often were made very quickly and implemented very soon thereafter. This provided a lot of challenges for payroll to keep up with all of these requirements under California law. The third reason for why these regular rate cases are very trendy or hot in California is because they're very susceptible to a group-wide action, whether it's a class action, collective action, or representative action, because they often premise on a uniform policy or practice on whether it's included regular rate or not included regular rate or how you calculate the regular rate. So there are common legal questions that courts tend to certify cases on a class-wide basis. And lastly, but not least, plaintiff's lawyer gets penalties and attorney's fees. That's what drives these plaintiff's lawyers for suing these cases. Now, on the next slide, we'll briefly go over the sick pay and then the COVID sick pay. I won't repeat what Chelsea already mentioned. Previously, California has identified two ways for calculating regular rate. Either it's based on the weekly regular rate calculation, or the employer can use a 90-day look back. Now, on the next slide, we have a couple of iterations of how COVID-19 supplemental regular rate pay had changed. In 2020 and 2021, the law was to require employers to pay the highest amount based on any of these four methods. That could create a lot of headaches and challenges for employers, especially when we're in a time where everybody's working from their home, either in the kitchen or at a dining table. human errors could occur. And these are the situations where employers can be vulnerable for a class action lawsuit or a PAGA lawsuit. Now, in 2022, the next slide will show that the legislature somehow clarified that the method for calculating COVID sick pay to largely track the way that traditionally we calculate for California paid sick time, which is just the regular rate or the 90-day look back. Now, on the next slide, we'll talk about regular rate of pay in the meal period context. So if you do business in California, you know that we're religious about providing employees with compliant meal periods and rest periods. And we'll talk a ton of, we'll discuss a lot about on these issues. Because employer gets sued so many times, many employers voluntarily comply or at least have a system to pay these meal premium payments whenever they could not provide a meal penalty or meal period to the employees. Now, under California law, if an employer does not provide a compliant meal period or rest period, they're required to pay an employees an additional hour at the regular rate of compensation. So what does that mean, regular rate of compensation? Previously, we talked about regular rate of pay because that is a phrase that repeatedly recurring in different types of requirements in California law, whether it's overtime, whether it's paid sick leave, whether it's reporting time. So the question is, does regular rate of pay equal or the same as regular rate of compensation? Well, on the next slide, we'll talk about the FARA case. This is a fairly recent California Supreme Court decision that squarely addressed this issue. The plaintiff worked as a hotel bartender and she earned hourly rate and some non-discretionary bonuses. So when she was not provided legally compliant meal or rest period, the employer already voluntarily provided an hour of pay, but at her base rate and not the regular rate of pay. The employer argued, like many other employers did, that regular rate of pay and regular rate of compensation is different because there's a long-standing presumption that the legislature, even the ones in California, knew what they're doing when they wrote the statute. When they wanted to say regular rate of pay, they put in regular rate of pay, but when they wanted to refer to something else, such as regular rate of compensation, they did it differently. Well, on the next slide, you'll see both the trial court and the Court of Appeal agree with the employer's position and its interpretation of the statute, meal period premiums. And the courts held that these two phrases are not synonymous because the legislature must intended the regular rate of compensation to mean something other than the regular rate of pay. Well, that's not true under the California Supreme Court ruling. The Supreme Court basically said that under the plain meaning rule or the dictionary rule that compensation and pay are interchangeable. And the Supreme Court also found that there was no evidence or any indication that the legislature intended to mean something different when they said a regular rate of compensation in the statute. So the holding in FARA was significant because contrary to a wide practice of many employers in California, where employers paid the meal or rest premiums at the regular rate of compensation at the base rate, the Supreme Court held that you have to calculate these rates on a regular rate of pay basis on a weekly basis to include any other items of compensation, such as non-discretionary bonuses. And to make things worse, the Supreme Court's decision applies retroactively and potentially exposing California employers to millions of dollars in potential penalties and liabilities. So with that said, we'll go to another Supreme Court decision. We fast forward to this year. The California Supreme Court issued another decision in favor of the plaintiff bar. If you have faced wage and hour class actions or PAGA actions, you'll know that there's common derivative claims that often attached to a wage and hour case. Waiting time penalties and wage statement penalties. Under the waiting time penalties, it essentially requires employer to pay all wages earned at the time of separation. And if an employer fails to do so, the California law imposes penalties up to 30 days of wages for any willful failure to pay all wages owed at separation. And waiting time penalties is available in action for non-payment of wages. On the wage statement penalties, the California statute provides statutory penalties at $50 per employee for the initial violation and $100 for any subsequent violation with a cap at $4,000. These two types of derivative claims are very popular in California because even if an employer fails to pay $1 in wages, that claim can trigger a large sums of penalties under waiting time or wage statement theories of recovery. To the next slide, please. With respect to the waiting time penalties, as I previously just discussed, waiting time penalties are available in an action for non-payment of wages. So the million-dollar question is, are meal or rest period premiums a wage? Well, let's go back, walk down memory lane. In 2007, the California Supreme Court issued the Murphy decision, finding that premiums are wages so that employees can have a longer statute of limitations to pursue against their employers. Because if it's considered a wage, then the employee has 3 years of limitation and 3 years to pursue the claim, as opposed to 1 year for penalties. Well, so fast forward 5 years later, when there was a prevailing employer sought to recover attorney's fees based on the reason or holding in Murphy, that it won, defeated a class action against an employee who claimed they were not paid or provided meal periods or were not provided these meal premiums. The Supreme Court flip-flopped and they decided that, well, a claim to recover meal or rest period premiums is not an action for non-payment of wages, thereby denying the employers the right to attorney's fees as a prevailing party. So subsequent to Kirby in the 2012 decision, many courts have followed the logical conclusion that meal premiums are not a wage to trigger a waiting time penalty in an action for the non-payment of wages. Well, in the next slide, you'll see that's where we're here today. In 2022, California Supreme Court issued a Naranjo decision that basically said that premium pays in the context of meal or rest period premiums are essentially the same as a payment for overtime premiums. It's to compensate employees for working overtimes or for working through a meal break. And the Supreme Court also rejected arguments that wages had to be tied to the amount of time worked. The Supreme Court cited to reporting time requirement or split shift pay requirements that are commonly considered wages, but don't really tie to the amount of time worked. So Naranjo held that an employer's failure to pay meal or rest period premiums now can trigger a separate cause of action for waiting time penalties for not paying all wages at the time of separation. But what about the wage statement claim? Common sense dictates that if the employer paid an employee $1,000 during this pay period and itemized all of that payment on a wage statement, the wage statement is accurate, right? Not so much. The Supreme Court said because the wage statement law requires employers to list all gross wages earned and net wages earned, you then as an employer, you should have listed the meal premiums or rest premiums that the employees earned. And the fact that an employer failed to do that, notwithstanding the fact that no meal or rest premiums were paid in the first place, that gave the employee an opportunity to trigger a wage statement theory of recovery as a derivative claim. So with that, I will turn to Chelsea, who will talk to you more about meal periods after learning all of the penalties that come with that.
As though that wasn't enough, right? Thank you, Leo. And we're all so glad that we have experts in these really nuanced wage and hour issues, because it certainly makes our jobs a lot easier as well. So that was really, really interesting. So thank you for that explanation. I do get the pleasure of talking about rounding and meal periods just for a few minutes to give you a little bit of a background, as well as an update of what's been happening recently. And I do want to obviously start with just a little bit of a refresher. We know what the law is on meal period requirements. We know that, at this point, a decade ago, the courts gave us Brinker and gave us a little bit more guidance that, our requirements around meal periods are to provide them, not to essentially, grab employees by the hair or drag them out into the street and force them to take their meal periods. We have a little bit of this focus on providing them, as opposed to that drastic response. Hopefully none of y'all are doing any dragging of your employees. But it also clarified the timing requirements. We've got that in Brinker, and that's very helpful as well. Since we're talking about both meal periods and rounding, I did want to give a refresh on the next slide about where things stand with rounding, as well. And that comes from the See's Candy case that happened also a decade ago. That didn't go so far as to say that rounding isn't permitted, but it does make it very difficult to obviously to have and demonstrate you have a good rounding system that's not unfairly burdening employees more than it is then it is benefiting them. And so it is really important to have those records to be able to demonstrate, if you're using rounding, that your rounding system is fair and employees are getting both the benefit and the burden, and not just the burden of that rounding system. And that brings us into the recent days with the Donahue decision, which brings up issues related to rounding and to meal periods on the next slide. Essentially, we had a company utilizing a rounding system that rounded employee time punches to the nearest 10-minute increment, and that rounding also applied to meal periods. And so they were using, so we all are aware, they were using an attestation around their meal and rest periods, but it was based on the rounding system itself. And so it's really something that doesn't play in or doesn't really help or didn't help them in this case. And this case had two very important holdings. The first one is that there can be no rounding when it comes to meal periods, and we'll talk about that and what that means in just a moment. But the second holding was that, if a time record demonstrates that these meal periods are not compliant, that actually is a rebuttable presumption that there's been a meal period violation. And so it's really important, if you look at the next slide, what that really means, this rise of the rebuttable presumption, essentially this assertion that an employee, it was relieved of duty, that an employer relieved the employee of duty, and that the employee waived that opportunity to have the work-free break. This isn't something that the plaintiff would have to prove. This is something that essentially acts as an affirmative defense that the employer would have to demonstrate. That burden is on the employer to demonstrate that. That means that if we have these non-compliant time records, the employer essentially has to rebut the presumption that the meal periods were improper. And so how do we do that? And we'll look at that, kind of the steps on the next slide of what are the ways in which an employer can serve to try to rebut that presumption, or at least reduce the damages if they're found in violation of the law. One of those is an automatic payment of those meal period premiums. We know that if the time records demonstrate that the meal periods were not given in the way that they're supposed to under the law, an employer can automatically pay the penalty for that. Obviously, that can result in overpaying the meal period premiums, and it doesn't completely eliminate, it doesn't make the violation go away, but it certainly can serve to reduce the amount of money that an employer would have to pay if they're found liable for those violations. And it will help also in managing individual and class liability. But one of the really important ways that we can serve to rebut this presumption on the next slide is through the meal period attestation system. Having an employee attest to whether or not they received a compliant meal period. If we have that in our timekeeping process or in our timekeeping system, that will help us be able to demonstrate that even if an employee ended up missing or taking a non-compliant meal period, it wasn't because we did anything. It was because it was provided to them, and they, without any pressure or any anything from us, they decided to essentially violate our policy or do this on their own. And so we do recommend those meal period attestations because it's one of the ways the court said, and you can even see it on the next slide, that we can demonstrate that we were doing all of the right things, right? They're looking for things like representative testimony, surveys, statistical analysis, and those meal period attestations could certainly serve to help us be able to demonstrate that we were doing all of the right things, and our employees, any choice that they made in order to not take a compliant meal period was completely on them and not because of something that we encouraged or wanted them to do. Now, in terms of best practices on rounding, we get this question all the time on the next slide. Is Donahue a precursor to the end of rounding? And we know Donahue didn't go so far as addressing rounding outside of the meal period context, but this is something that remains a really open issue. We see rounding very often, and we always stress to our clients that we want to make sure that if rounding is being used, we're doing things behind the scenes to ensure that that rounding practice is fair and there is that balance of benefit and burden. But it does serve to defeat the purpose of the ease of a rounding practice if you have to go through those additional steps and make sure your time records are to the minute and showing exactly where our rounding benefits employees as well as burdens them. And so the practical advice that we commonly give is that, why are we rounding? What are we getting out of a rounding program that isn't kind of balanced out or avoided out by all of the other things we have to do to ensure its validity? And so that does tend to be our, kind of our practical advice that rounding may be on the way out. And if it's something that you're using, really look at why, and maybe it's something that you could consider moving away from because there's just a lot more involved and it becomes a lot more difficult, maybe not worth the trouble as much anymore as it might have been. And on the next slide, in terms of best practices for meal and rest periods, obviously we want to make sure that our policies reflect the current state of the law, making sure that our employees and our supervisors are trained on what our requirements are. And even though a policy and training aren't technically required under the law, you can hear how I'm saying it in this very measured way. We know how helpful and how useful having good policies, having good training is when you're defending yourself. When Leo's helping you out in one of these meal and rest break claims, we want to position you in the best way we can. And having great policies and trainings in this area is going to be, your first line of defense to be able to manage these things. In additional best practices on the next slide, thinking about things with respect to the scheduling, timing, length of meal and rest periods. Obviously, number one, we know from Donahue, eliminate any meal period rounding if you are if you have that practice in place. Make sure that you don't continue to do that, but also look at some other ways to limit potential exposure. Can you move your meal periods to be a little bit longer than 30 minutes? Can you go with a 35-minute meal period, a 15-minute rest period, so that you know that you're not worrying about that 1 minute, those 29-minute meal periods that wouldn't be technically compliant. And then, of course, scheduling your meal periods in the day so that they're early enough to ensure we don't run over the, that 5-hour limitation, having them make sure that they begin at least 30 minutes before we get to the end of that 5th hour of work. These are the types of things that really can help us, very simple steps to take a step backwards and recognize that we can reduce liability in a host of other ways. And of course, on the next slide, one of the best practices we're certainly recommending is timekeeping attestations. Donahue does not go so far as to say you have to have attestations, but we recognize that this is certainly a best practice. It gives us an ability to cover a whole host of issues, not just our meal periods, but also hours worked and rest periods, which other than having a great policy and making sure that we're following that policy, without an attestation, we don't have a great system in place to be able to demonstrate that all of the rest periods were taken. And so it's definitely something we recommend. We want y'all to be thinking about, looking into, because it is a great way to be able to defend, if we're ever in the position to defend our meal and rest break practices. We'll have those attestations that'll really help us, whether they're hard copy if you're using time cards or they're in your timekeeping system because you use a punch clock. There are several ways that one can address this. And, giving some sample language, although I really do recommend, reaching out to us, reaching out to some of our other wage and hour experts like Leo to walk through exactly what we think would make a great attestation, depending on what your system can tolerate. Obviously, there's no one size fits all for everybody, but it's certainly on the next slide, some examples of some of the things that we would want to see. But again, I think the best idea here is to reach out to your favorite neighborhood wage and hour attorney and talk through what your system can tolerate, what makes sense for your business in terms of a timekeeping attestation. And of course, speaking of our favorite wage and hour lawyers, I'll pitch it back to you, Leo, and have you talk about one of our favorite topics, which is, of course, PAGA.
Thank you, Chelsea. So PAGA is a unique creature of California, and PAGA cases remain popular as ever in California. And recently, just a fun fact, at least one firm in California has surpassed the 1,000 filing mark since 2009. And that number is astonishing because that averaged out about 100 case filings per year. So, and there's that. Now, as a quick recap, PAGA is a type of qui tem action or a type of bounty hunter law that allows an employee to step in the shoes of the state of California to pursue civil penalties of various labor code violations. The recovery can vary, but the default amount is usually $100 per employee per pay period for the initial violation and $200 per employee per pay period for each subsequent violations. So by stacking these penalties based on different theories of liability and coupled with a large workforce, the penalties amount can balloon to an astronomical number for any employer. Now, the statute is poorly written in a way that invites potential abuse. So, for example, there is no class certification requirement in PAGA cases, even though a part-time seasonal employee can bring a PAGA action that covers the employer's entire workforce in California for thousands or even tens of thousands of employees. PAGA also gave broad standing to sue. An employee who worked off the clock for one shift for 1 minute has standing to do a thorough audit of the entire company's payroll practices for potential regular rate violations, for instance, or whether expense reimbursements were paid on a timely manner. A PAGA plaintiff also gets to drive up litigation costs in discovery. The California Supreme Court has extended PAGA discovery as broadly as class action discovery. And without class certification requirements, PAGA discovery can arguably be more expensive than class action discovery in some cases. Also, because of the proliferation in PAGA filings, many courts do not consider PAGA actions as complex cases. So oftentimes an employer may end up before a judge who has very limited experience in wage and hour law, let alone experience in managing class action cases. So that's a very disadvantaged sort of tactical issue for employers. To make things worse, most of the employers cannot remove PAGA-only cases to federal court because PAGA is not a class action. On the next slide, we'll introduce the first major development in PAGA cases. It deals with the decade-old debate on manageability requirements. So the first case came out September of last year in Wesson versus Staples. The Wesson case involved a misclassification case where the plaintiff store manager argued he and others were misclassified as salaried exempt employees. When the trial court ordered the plaintiff to produce a trial plan to discuss how the parties could litigate Staples' exemption dispenses, the plaintiff argued that he's not required to do so because Staples had the burden of proof on his exemption defense. So after Staples filed a motion to strike, the trial court granted the motion and dismissed the PAGA claims based on manageability grounds. The Court of Appeal from the Second District affirmed, holding that defendants have due process right to fair opportunity to litigate their affirmative defenses, and that the trial courts have the inherent authority to ensure PAGA claims can be fairly and efficiently tried. So Wesson was decided in September 2021, and the employers and defense bar rejoiced for about 6 months before a different appellate district court issued a decision in Estrada on March 23rd, 2022. The Estrada case involved a run-of-the-mill meal and rest period wage and hour class action and a PAGA action. The trial court in Estrada actually denied certification and then denied defendants' motion to decertify before holding a trial, a bench trial. And after the plaintiff rested, defendant again moved to decertify the classes. The trial court then granted the motion with respect to the meal period subclass and also dismissed the related PAGA claims based on manageability grounds. The Court of Appeals from the Third District disagreed, however. It expressly disapproved Wesson and concluded that courts cannot impose manageability requirement to dismiss PAGA claims because such a requirement does not exist to enforce enforcement actions by a state agency. In light of the split amongst the state appellate courts, the California Supreme Court has granted review of the Estrada, I think, last month. Now, the Ninth Circuit also joined the party. About 2 weeks ago, the Ninth Circuit weighed in on the issue and dealt with another blow to the employers. The court in Hamilton sided with the reasoning in Estrada and essentially held that federal district courts do not have the authority to impose additional requirements that would contradict California law or undermine key features of a PAGA action. So for those PAGA cases pending in federal courts, the Ninth Circuit's ruling is binding precedent and makes it that much harder for employers to challenge or attack PAGA cases on manageability grounds. So we probably will not find out whether trial courts can strike PAGA claims based on manageability grounds for another 2 to 3 years, possibly until the Supreme Court has ruled on that issue. Now, moving on to the Viking River cruise cases. There was some good news came out of the United States Supreme Court last month in Viking River cruises. In that case, the plaintiff had a binding arbitration agreement that contained a waiver to pursue any type of group-wide action, such as class action, collective action, or PAGA actions. However, previously, the California Supreme Court had held in 2014 in Iskanian that a PAGA waiver under the arbitration agreement is not enforceable as a matter of public policy. And because PAGA claims cannot be split into individual claims and representative claims, employers cannot compel arbitration of a plaintiff who signed an arbitration agreement. Well, the next slide, the US Supreme Court held that FAA, the Federal Arbitration Act, FAA, applies and preempts the California Supreme Court's ruling in Iskanian that PAGA claims cannot be split into individual and representative claims. The US Supreme Court held that a prohibition on contractual division of PAGA actions into individual and representative claims runs afoul of the FAA and therefore is preempted. The court also explained that a defendant cannot be compelled to submit representative claims to arbitration unless they contractually agree to do so. So the US Supreme Court then concluded that representative PAGA claims cannot survive on their own after the individual plaintiff is compelled to arbitration with respect to their individual PAGA claims. That was a little bit tricky because Justice Alito, who wrote the opinion, made a determination that California PAGA statute has a standing requirement that required an aggrieved employee to have standing to be able to bring his or her individual PAGA claims in order to represent or pursue or prosecute the representative claims. So on the next slide, we'll talk about the impact of Viking River. The million-dollar question is, does Viking River put an end to PAGA cases and the potential abuse? Not so fast. The general consensus amongst the experts, the PAGA experts, is that PAGA claims are here to stay. And here are some reasons. One, if an employee did not sign an arbitration agreement, they can pursue a PAGA action even if other employees have signed arbitration agreement. This issue then turns to the long-held debate about whether arbitration agreement should be mandatory or voluntary. When an employer has a voluntary arbitration policy, it runs the risk of having someone without arbitration agreement bringing a class action or PAGA action. Even under Viking River Cruises, that person has the standing or ability to pursue a PAGA action. The second reason why Viking Rivers had limited application or impact on employers or PAGA cases in California is that, as Viking River made clear, a wholesale PAGA waiver is not enforceable. So I highly encourage everyone to consult with their outside counsel and expert to review their existing arbitration policies or agreements to make sure it complies with the Viking River standard and the holding in Viking River. Third, Justice Sotomayor's concurrence is somewhat troubling for employers and could potentially unravel everything that has gained from this, very well-written decision. Remember, Justice Alito's majority opinion is based on the interpretation of a California statute on the standing requirement. If a California court disagrees with that interpretation, or if is legislative amendment or clarification on the issue, it could undercut the holding of Viking River altogether. And we have already heard chatters that the PAGA statute will likely to be amended to circumscribe the holdings in Viking River. The last two challenges for employers are very common or nothing new. There's always the risk of not timely enforce the arbitration agreement to allow a plaintiff to get out of a binding arbitration agreement based on the waiver arguments. Recently, the U.S. Supreme Court also issued another decision in Morgan versus Sundance that eliminated requirement to show prejudice in the context of waiver issue. So the employer should be aware of this and timely seek the enforcement arbitration to avoid any argument about waiver. Lastly, as with class actions, there is always the risk of mass arbitration. In California, employers are required to cover 99% of the arbitration fees. And California has passed a law that requires employers to pay the arbitration fees within 30 days to avoid waiving the right to arbitrate. So the risk of mass arbitration can be problematic for some employers with large workforce that has a high turnover rate. So the question about whether to have an arbitration agreement, whether to have a mandatory or voluntary, things to mitigate these risks in light of Viking River, I strongly encourage everyone to talk to your experts and find a solution that fits your business needs and your practice. Now, I'll conclude my Wage and Hour update with a more upbeat news on the next slide in the LaFace versus Ralph grocery store suitable seating decision. On this slide, you'll see suitable seating law has two components to it. Under Section A, an employer must provide suitable seats when the nature of work reasonably permits the use of seats. And separately, under Sections B, employers must provide seats during lulls in operations when it does not interfere with the performance of their duties. So in 2016, the California Supreme Court issued a decision in Kilby that set the standard of this totality of circumstances approach that required courts to weigh several non-exhaustive factors to determine the reasonableness for providing seats. This what really does was to create additional challenges for employers who seeks to dispose of suitable seating claims on a dispositive motion for summary judgment. Now, on the next slide comes with LaFace versus Ralph, where the trial court held a 3-week bench trial in Los Angeles the plaintiffs consisted of cashiers who spend most of their time scanning items, interacting with customers and bagging groceries, and they also have some other duties such as cleaning and stocking. The trial court ruled in favor of Rouse, and the plaintiffs appealed. The Court of Appeals affirmed the trial court's ruling and provided some good sound bites for employers to use in other seating cases. I included a couple on the slide. Another good ruling about, well, let me go back. The appeal is worthy to note. The appeal was limited to Section 14B, the lows in operation. That's because plaintiff abandoned the 14A requirement on the appeal. So the LaFace appellate decision has little value to the 14A analysis, although you can borrow some of the language that the court had in its opinion. So on to the next page. The other good part of this LaFace decision is that the Court of Appeal, in a published opinion, ruled that PAGA actions are not subject to jury trial. The prevailing wisdom is that if you have a bench trial, the PAGA trial will be less costly, and it allows the court to conduct PAGA trials more efficiently. So to some extent, this is a good development on how to try PAGA cases, and provide some arguments for employers when the plaintiff is seeking to have a full-blown jury trial that can be very costly for the employers. So I will end on this high note and turn over to Anne-Marie, who will be discussing some of the new restrictions on separation and settlement agreements.
Thank you very much, Leo. That was a very informative and thorough update on California wage hour developments. Next slide, please. So on the next couple of slides, I've included some pre-2022 developments with respect to California settlement and separation agreements for you to review at your convenience. We just have time today to cover the 2022 developments, but the 2022 developments are based and premised on some earlier developments. So on slides 72 and 73, we've included a summary. So if we could skip ahead to slide 74. So here we have this year's developments. So first, California law now bars provisions in settlement agreements entered into after January 1st of this year that prohibit or prevent the disclosure of facts related to all forms of harassment, discrimination, and retaliation. So prior to 2022, it was limited to prohibit facts related to sexual assault, sexual harassment, or sex discrimination. Now it's all forms of harassment, discrimination, and retaliation. But a little bit of good news, it's still possible and permissible to prohibit disclosure of the amount of the settlement payment. Next slide. So separation agreements and non-disclosure agreements, even outside the context of separation. So, you know, if you have a standalone non-disclosure confidentiality agreement during employment. So as of the first of this year, confidentiality and non-disparagement provisions in employment and non-disclosure agreements that have the purpose or effect of restricting disclosure of information about harassment, discrimination, or other conduct that the employee believes to be unlawful are prohibited. Next slide. So as a result of that prohibition, California law now requires that you include certain language in your separation and non-disclosure agreements to make clear that employees are not prohibited, you know, from disclosing information about unlawful acts in the workplace, such as harassment, discrimination, or any other conduct that they believe to be unlawful. So essentially, it's a required carve out or exception to a broad non-disparagement or confidentiality requirement. This caveat or carve out does not apply and is not required to be included in negotiated settlement agreements to resolve an underlying claim that was filed. The good news is it doesn't have to be a claim that's filed in court or with an agency. It could be a claim that is filed you know, under your internal complaint process. So if it's a negotiated settlement agreement to resolve even an internal claim, you do not need to include this carve out. Next slide. So for all employment agreements, excluding negotiated settlement agreements, the employer now must notify the employee that the employee has the right to consult with an attorney regarding the agreement and provide an employee reasonable time to do so of not less than 5 business days. Keep in mind, under the Federal Age Discrimination and Employment Act, for those employees who are over or age 40 and over, in order to release age claims, you've got to provide them with a 21-day consideration period. Next slide. So with that, I am going to pass it back to Chelsea to talk about some important CFRA updates.
Yeah, thanks so much, Anne-Marie. And, you know, there wasn't a lot this year when it came to the CFRA updates, but we did want to make sure that everybody was all caught up from what happened last year, since that was such a significant batch of updates that, you know, now is as good a time as any to catch up if you haven't already made these changes to your policy. You know, last year we had SB 1383, which was a very significant expansion of what CFRA does. It essentially eliminated the mileage threshold. You know, for FMLA, it's 50 employees within 75 miles. It essentially eliminated that mileage threshold for CFRA and lowered the number of employee threshold from, it was 50 for most types of CFRA, but 20 for parental. It lowered it down to 5 employees anywhere in the U.S. So long as the company, you know, just has that 1 employee in California. CFRA is going to apply to companies as small as 5 employees. It also expanded some of the definitions within the law, including the definition of child for, you know, providing care if a child was an adult child. You know, CFRA now has the ability, for example, for an employee to take time off to care for a child who has, you know, has just given birth, for example. And so adult children are included in CFRA, and the new law as of last year made it very clear that that was the case. If you look at the next slide as well, it also expanded the list of covered family members to include grandparents, grandchildren, siblings, as well as expanded the reasons for use under CFRA to include qualifying exigency, very similar to how it's described under FMLA, but not exactly the same. And so we now have to recognize, and what we've been seeing a lot of clients struggling with, is there are so many reasons now where FMLA and CFRA are not going to run concurrently. We used to have very few reasons. Now we've got a much longer list of those situations. If someone were to take a leave of absence, for example, to care for a family member, a sibling who has a serious health condition, that's going to come out of their CFRA bucket, but it's not going to come out of their FMLA bucket. So that's a very important distinction. We also want to make sure that everybody's aware that because CFRA does have a written policy requirement, we want to capture all of these updates and make sure that our CFRA policies are compliant, you know, through 2022. And we'll talk about the tiny little change for 2022. But it's important, since there was such a significant change that happened at the beginning of 2021. If you have not reviewed your CFRA policy in the last couple of years, Now is the best opportunity to do that because there was such a dramatic change that occurred in 2021. Take a look at it and make sure that you're in good shape. But bringing us forward on the next slide to what happened at the beginning of 2022, this is a very minor tweak. If you looked at the law in 2021, you would see reference to parent-in-law, but it wasn't included as one of the covered family members. It didn't really seem to make a ton of sense. It was one of those, maybe somebody missed something, but the regulations that came out after that made it very clear that they did not intend to include parent-in-law as a covered family member, but all bets are off starting 2022. AB 1033 added or corrected this, if you will, added parent-in-law to the definition of who is a parent for purposes of taking time off for CFRA. And there are handbook implications, obviously, for that as well. If your handbook currently goes into detail and defines parent and includes things like step parent, and other types of individuals who would be considered parents under CFRA, then we definitely recommend that you go and include parent-in-law to the list. Obviously, if you don't define parent and you just know not to deny leaves for someone wanting to take time off for a step parent, et cetera, well, you need to be doing the same or treating it the same for purposes of parent-in-law after the beginning of 2022 as well. So it's important to kind of recognize that. And on the next slide, just action items. Obviously, everybody run to your handbooks. I know I've got my stack of handbooks always at hand, but go to your handbooks as quickly as possible. Assess whether you have made these changes for 2021, and then determine whether, if you already made changes in 2021, if you do need to make that small tweak to come into 2022. And also make sure that your managers are aware that the definition of parent, just like the definition of child, they're very broad, and it's not as simple as someone's biological parent. It could be a whole list of other individuals, and that now includes parent-in-laws as covered family members for purposes of CFRA. So we always encourage you to reach out to your favorite member of the Seyfarth handbook and policy team to get those tweaks made and make sure your policies are in great shape. And so with that, I will turn it back to Anne Marie to wrap us up for today with our last section on the Great Resignation world of work.
Thank you so much, Chelsea. And yes, we wanted just to take a few minutes to close out today's program with talking a little bit about work culture assessments, and in terms of why we've included it here. We think it's an important development for 2022, not because of a change in a statute or regulations, but really to step back and take a look at where we are in 2022 with COVID, post-COVID, sort of we're in a period of transformation and just significant changes in the world of work, where work is performed, how work is performed. Much of it is still being done remotely, where employers are requiring employees to come back to the office. Often it's not full-time. A number of clients have adopted hybrid work policies requiring employees to be in the office, say, 3 days a week and permitting them to work from home the other 2 days of the week. And so a lot of clients are struggling with how to maintain their work culture, and also ensure that their work culture is consistent with their mission, vision, and values, their business objectives, and also their legal compliance objectives. And so what a work culture assessment is and how we can help is we have been partnering with a number of clients to look at their work culture and the clients, their expectations, their behaviors, their policies and practices, and really confirm that they are consistent with the culture that they desire, the culture that they want to foster in order to attract the best talent and to retain top talent once they arrive. And so we can do that by helping you with your policies, practices, and taking a look at whether they're sufficient or whether we can identify areas where you can make changes to so that they're better aligned with your objectives. Next slide. So why a work culture assessment now? Like I said, we are just in one of the most transformative periods in history in the world of work, and it's not just COVID or the Great Resignation. It's also just AI, technological advances, really generational differences. If you're like many employers, you're struggling with just how millennials see work and their relationship with work differently than those of other generations. And really, work culture is more important than ever in order to attract and retain and motivate top talent. Next slide. So on the next slide, we've just put for you some of the overall goals, listed for you some of the overall goals of what a work culture assessment can accomplish. And on the following slide, we have included the elements of what a work culture assessment entails, in case you're interested in looking at your culture and seeing if there are ways you can, remain competitive at both attracting top talent and retaining employees once they arrive. Next slide. So with that, I am going to wrap up by reading that important code that you've all been waiting for. So the CLE code is Seyfarth, is SS as in Seyfarth Shaw 5699. Again, SS 5699. And with that, that concludes today's program, exactly on time. And we'd like to thank you all for attending today. We've got our contact information. In case you have any questions, please don't hesitate to reach out and contact us. And with that, we hope that you all have a great rest of your Friday and a great weekend. Thank you so much.